In this legal vision, I would like to talk about amendment in FCRA. It is also tabled in Lok Sabha and it may get passed in the Lok Sabha and Rajya Sabha also. And it is significant amendments. It is connected with the Article 19(1) that's also of our Constitution. At the same time, it is not affecting the Article 25 of our Constitution. It is very significant because in order to protect the sovereignty of India and the integrity of India, the FCRA rules are amended. But the strict compliance are expected from the non-governmental organization. The organization should have been registered under the Society Registration Act and Trust Act and the Companies Act. The purpose should not be conversion. That is main aim. Because many organizations are receiving the fund, the foreign contribution, without naming the donors, getting overall funds as also, and for conversion, the funds are misused. So to control misusing and to take action on misusing of the foreign contribution, the amendments now have been brought. So the nodal agency is the Ministry of Home Affairs, Government of India, and prior permission is needed as well as the the prior permission and the registration is needed to get this also the foreign fund under the FCRA. Foreign Contribution Regulation Act is a very significant act. But initially, the most organizations received the fund under the previous regimes, and all the NGOs, maximum NGOs misused. But now the compliance is expected under the new rules. Under the new rules, if the agency or NGO has left the service, it has to submit all the assets created under the foreign contribution. What are the assets and how the assets are maintained, everything. All have to be submitted with the government of India. That regulations and many people are resisting because they are misusing the assets. Misusing the assets. You can take many agencies, many NGOs in India, particularly in Tamil Nadu also, the many agencies they have constructed, they have captured the land, have constructed the assets. The assets are being misused. And those have to be submitted with the government of India when the agency is leaving it. So the purpose is very important. The objectives of the regime receiving the foreign contribution. So for that purpose, the donor has to be stated. Those donors are also social media activities and as well as completely the activities of the donors in foreigners also have to be submitted. The NGOs should contain the Indians and also may contain the foreigner. If it's a foreigner, so those submission are necessary, much necessary. If the person is also is in the NGOs, even if it's a foreigner, the strict rules should be complied with. So that's why the reason the neat paper leak agitation was misused by all these people. That's why the Supreme Court of India has stated very clearly the cases should be classified into two parts. One part is no case person, another part is a case person. So that only the identification can be done easily, action can be taken accordingly. And those are must, and those have to be regulated. And these necessities that also should be felt. So the FCRA can be opposed by the opposition parties and other things. Because the political parties hereafter can't receive the foreign contribution. The politician can't receive it, only in the NGOs. So the NGOs also should be strictly following and complying with what the rules, new rules are stating. So I think these new amendments will be helpful for strictly protection of the also Indian sovereignty. The India sovereignty and integrity are must. because we have to protect our nation. And recently, and the 2022, the Supreme Court of India has stated in its order a biggest one: protection of integrity is must. Instead of there's also humanitarian service and other things also. So the FCRA amendments are best one, most to receive. Thank you.